let's talk about Code of Professional Responsibility and Accountability. It's in the new uh, Code of Conduct of Lawyers, which is the CPRA. It's found in Administrative Matter number 22-09-01-SC. Okay, again, it's AM number 22-09-01-SC. So let's talk about Canon 1, which is the independence or merit-based practice. So this discussion will only talk about those which are focused on the bar exam. So if you want to read the whole provision, you can just read it in the said administrative matter. So let's begin. In Canon 1, let's talk about independence and merit-based practice. So, the independence of a lawyer in the discharge of professional duties without any improper influence, restriction, pressure, or interference, direct or indirect, ensures effective legal representation and is ultimately imperative for the rule of law. So, the highlight of this is about the independence of a lawyer in the discharge of his or her professional duties. Let's talk about merit-based practice. A lawyer shall rely solely on the merits of a cause and not exert or give the appearance of any influence on nor undermine the authority of the court, tribunal, or other government agency or its proceedings. Let's take the case of Asuncion versus Salvado. It's a 2022 case. So here, the text messages prove complainant's allegations of influence peddling in violation of uh, Rule 15.6, which states that a lawyer shall not state or imply that he is able to influence any public official in tribunal or legislative body. From the exchanges, it is apparent that respondent planned to procure the decree or decision of annulment using his connections and not his skills as a lawyer. Canon 13 states that the lawyer shall rely upon the merits of his cause and refrain from any impropriety which tends to influence or gives the appearance of influencing the court. So that's what happened in this case. It does not depend on his skills as a lawyer, but is using his tactics to procure the decision of annulment through his connections. So, hindi dapat ganun, no? Hindi porket malakas tayo sa judge or sa ano, ginagamit natin yon to our advantage. We must rely solely on our skills. No? That's why we should be independent. And through merit-based practice, we apply these principles. We also have the case of Liam versus Bautista. It's a 2023 case. So, in this case, there is substantial evidence presented that the money was exchanged in consideration of the legal services of the respondent and for the mobilization of the latter's contacts at the National Prosecution Service. Example is the Office of the City Prosecutor of Makati, intended to ensure that a resolution favorable to the complainant will be issued. So, doon pa lang sa city prosecutor, may nagaganap ng corruption, di ba? There was an exchange of money. So, respondent tainted the image of the National Prosecution Service. Okay? So, the lawyer's act of influence peddling or implying that he is able to influence any public official, tribunal, or legislative body erodes the public's trust and confidence in the legal system and puts the administration of justice in a bad light. So, yun yung ginagamit ng mga ibang lawyers, no? They'll say na bigyan mo ako ng pera, asikasuhin natin yung kaso mo in your favor, which is very unethical and wrong. Okay, so erring lawyers who are guilty of influence peddling, yung tawag natin, influence peddling are unworthy of the title of an attorney. So if the allegations against them are properly substantiated, as in this case, in Limbaugh versus Bautista, they must be meted the most severe penalty of disbarment. So, deserve lang, di ba? Disbarment talaga ang pataw dyan. So as an officer of the court, respondent has the paramount duty to protect the integrity of the court and the National Prosecution Service and assist in the administration of justice. So instead of relying on the merits of the case and fighting for his client's cause with competence and diligence, respondent presented that the National Prosecution Service and the administration of justice can be bribed and bought. Okay? So, Rod, Rodco Consultancy and Maritime Service Corporation versus Conception, this is another case, disbarred, no, a lawyer who solicited approximately 500,000 pesos from his client and made it appear to it will be used to pay the alleged connection at the CA or Court of Appeals. So dito sa CA naman kasi kanina sa Office of the Prosecutor sa Makati. So we also have the case of Yoshimura versus Panagsagan. In this case, it also ordered the disbarment of a lawyer who demanded money from his client, purportedly to be used as a bribe to expedite a transaction. Dami nangyaring ganito, no, na para just to expedite the proceedings or for the proceedings to be in your favor, hingi yung lawyer ng pera. So, it's influence peddling. So, Pacana Jr. versus Pascual Lopez, another case. It imposed the supreme penalty of disbarment on a lawyer who committed acts of dishonesty, influence peddling, and failure to render an accounting of all the money and properties received from her client, which amounted to at least 12.5 million. And also, we have the case of Asuncion versus Salvado, where the Supreme Court disbarred a lawyer who engaged in influence peddling and promised to secure a favorable annulment decree. Parang nakita ko to sa Facebook, medyo uso na na sabi magbayad kayo, magkakaroon kayo ng favorable annulment decree, madaling maanal yung kasal nyo. So, yun nga, in exchange, dito sa case na to, in exchange for 700,000 na tatapos na daw in just 2 months. No? Ganun kabilis. So, yun yung kapalit, disbarment kung gagawin mo to as a lawyer. Pero nga, di pa lawyer, nangangako na, di ba? So, yun. So, we also have the case of Judge Dumlao versus Camacho, which is a 2018 case. The issue is whether or not the respondent should be administratively sanctioned. The Supreme Court said yes. The court finds that the respondent violated the code and the lawyer's oath for influence peddling, attempted bribery, threatening court officers, and disrespecting court processes. So in the case of influence peddling and attempted bribery, because a lawyer is duty bound to actively avoid any act that tends to influence or may be seen to influence the outcome of an ongoing case, lest the people's faith in the judicial process is diluted. So a lawyer that approaches a judge to try to gain influence and receive a favorable outcome for his or her client violates Canon 13. And on the other hand, bribery is classified as a serious charge that constitutes malfeasance in office. And a lawyer who commits attempted bribery or corruption of public officials against a judge or a court personnel violates Canon 10 and Rule 10.1. Okay, so for the next video, we'll be talking about Canon 2, which is propriety. Again, this is the new code of conduct for lawyers. Okay, the CPRA.